everybody, Excited Utterance here, and guess what? Everything's just working out roses for me at the moment because I woke up and Darlie messaged me and he said, you know what, Pella, the Sarah Boone hearing didn't happen today, or it didn't get streamed today. And I was like, never mind. Never mind indeed, because I'll just run body cams today. And I stayed in bed for, 20 minutes or so. And then, guess what happened then? I was, messing about. And then he goes, guess what, Helen? Guess what? It's streaming now. And I was like, well, isn't that lucky for me that I didn't stay up last night and try to stream it live? Aren't I a lucky duck? Yes. You hate the intro music, Justin? Well, you're in a minority. So, how's it feel to be in a minority group? Because I know lots of people like it. Too bad, so sad. My co-worker intro music is nice, though. You like that, right? Who doesn't like a little bit of Ride of the Valkyries? Yes. Sarah waited for Hella to be ready. Yes, see, Sarah loves me because I'm the only one who sticks up for her. Justice for Sarah Boone. So I'm sure she had something to do with it. She's got no control over anything else that's happening whatsoever. But somehow she managed to make it that her court hearing didn't get streamed until Hella got out of bed on the other side of the world. That's what happened. Thank you, Sarah. Not intentional. Very much. It's too much going on. It makes your head spin. Oh, well. At least Rackets had a license. What for what? Hey, Josie. How are you? Good to see you. Good to see you. Team for Sarah Boone. I tell you what, this week I have been in my comment section responding to all the people who hate me. And they're like, how can you defend her? How could you defend this filthy murderer? I'm like, I'm not. But I don't like what's happening to her in court right now. I really don't. And P.S., I've been watching the live stream as it's been coming through over the last hour or so, and I like it even less. Because I'm not going to do any spoilers. We're going to watch it. But she's been pretty nice in court. She's been sitting there. Hello. Why you let yourself in?
I didn't. Oh, shit.
This is my time to have my little rant.
Sorry, I hit the wrong button.
Fine.
Sorry.
How are you?
I'm sorry.
Hi.
I meant to bring up my window instead of yours, and yeah.
Yeah.
I'm sorry.
Yeah, you're just like, let me in.
I know. I was like,
you're a bit like George. You're like, Sarah.
Hella.
Hello. Hi, Darlie. This is my co-host, Darlie, if you don't know. Yes. I'm getting a lot of people watching these streams, like, after the fact. Quite a few views because people are a bit mad at me. And anyway, so I've been in my comment section, so trying to explain that, guys, I'm not defending her actions. I don't think she did the right thing by putting her boyfriend in a suitcase. Like, that's not right. And also, even if I'm to accept the fact that the court has waived her right to a public defender and go, okay, so she's just intolerable. Fine. All this stuff about her sacking 8 lawyers, that's not right. She sacked nobody. They dumped her, and there's not been 8, there's been 4. 4 of them conflicted out. So can we just stop all this talk? It's hyperbole, right? All of these things, they're misinformation. People are just latching on to this story, which is quite dramatic, and people love drama.
Yeah.
People love drama. So I'm going to let the whole thing go about whether or not the judge did the right thing by waiving her right to a public defender, because it's done now. Now I'm more interested in how she's treated leading up to trial, because that's what's being discussed in this hearing. Now, what her situation is, being treated as a pro se defendant I feel that Judge Kranick is being a bit of a dick, to be honest. And Sean said the same thing. Really, he could be a little bit more hospitable, considering that he's the one who's decided that she's in this situation. She's in jail. It's one of those open plan jail situations. So she's sitting there with a bunch of other people, zero privacy. And when I say zero privacy, literally like 100 other jail inmates around her all the time. It's not a cell. She's an open plan. She has one little drawer, and she has no access to anything, no internet, phone calls that last 15 minutes and they're monitored. This laptop that they keep talking about, they still haven't given her. And when they do give it to her, who knows whether it's even going to have charge because they're not giving her a cord because of like strangling risk or something. The discovery, it's now, 2.5 weeks late, and no talk of a continuance whatsoever, even though she's now in this situation where she has to represent herself. So, okay, is it enough of a punishment that she has to represent herself? Is it? Or is he going to push it even further and make it even harder for her? Can't there be some allowance made? Can they all not work together, the court, the jail, everybody involved, to try and make it a little bit easier for her? I think she's probably in a bit of a tough enough situation. And I think that a continuance should be granted immediately. That's how I feel about it. She's already not going to get a fair trial. Hello, everybody. Jenny, how's it going? John Forever, the court hearing was streamed. I missed it. Yeah, you're going to watch it right now. Oh, could you, Hella? Oh, snivels. And Donna Barkley is there here. Hello, Donna Barkley. And Merv, you. Can you explain the 4 versus 8? Oh, yeah, sure. So 4 of them conflicted out. 4 of them immediately recused themselves because they had conflicts. So I think like they knew a witness or...
Well, Scott Wade says 3. The first PD was replaced in a week by Sarah's hired lawyer.
And the first PD was replaced in a week by Sarah. I went through the motions to recuse yesterday. And what do you mean replaced in a week?
Well, she hired a lawyer.
Yeah, her ex-husband hired one for her. Okay. So one of them wasn't a court-appointed one; it was actually a hired one.
So she's only had 7 court-appointed ones.
Apparently, but I don't know why. Well, so the one that was replaced,
mm-hmm.
I don't know. I read conflict in the recusal, so I don't know, because I saw 4 motions that said recusal on it. Conflict on it. So I'm going to have back and have a look at that. But thank you for that. I appreciate it. So yeah, Murph, that's why. And good to see you, Murph. Good to see you, Murph. So there's definitely not been 8. So I have a problem with people going around saying she sacked 8. She sacked no one. And there's certainly not been 8. Certainly not been 8. Yeah, she's in a pod, one of those pods. The first PD was replaced in a week by Sarah Tyler. Yeah. 7 court-appointed, 1 hired. She hasn't fired any. No, they've all sacked her. Right? So people are getting around with all these stories about her sacking lawyers. No. And also, I don't want to dwell on this for too long. I want to get into the hearing. But also, I've been through the court's 16-page order, and I've had a look into a few of the case laws that the judge has cited, and they're really, really different to Sarah's case. Like, really different. Like, we're talking about defendants that have physically threatened their court-appointed attorneys and threatened their families, like lunged at them kind of business style. One of them, the one that I found that was kind of similar, looked kind of similar on the surface, actually that defendant was in between the court-appointed lawyers, representing himself pro se by choice because he thought he was a better lawyer, and was saying that all of these lawyers didn't know what they were doing because he knew law better, right? And he did go ahead and actually ask them to step down. Like, he did sack them.
Yeah.
Whereas Sarah never did anything like that. So I'm finding it, I haven't been through all the cases that this judge has cited, but the ones that I have looked at don't really look much like Sarah. So, I mean, I'm not a lawyer. I'm just trying to see where this judge is coming from, because it does seem to me like a really drastic step.
Yes.
Especially considering there's only been 4, not 8.
Well,
she sacked at least one person. Okay, but that was not a public. If she sacked someone, it was not a court-appointed attorney. It was someone that was fired by her ex-husband.
Yeah.
So,
all right.
If she sacked someone, let's get into it. Finally, the video is out. It was so disappointing this morning. I'm sure there were lots of people disappointed, but hey, you won't be disappointed here. Let's get into it. I was like, hurry up.
What?
We're in the wrong setup.
That was Court TV's intro this morning. Oh, that setup, yeah.
Okay. It's because it's a premiere. The premiere on YouTube, you can't do anything about it.
No, I know.
Stupid gay premiere intro thing.
They added to all premieres?
She sacked George. Hey, stop it, Justin.
I thought they add this to all premieres.
Peter Trapos is, oh my god, Trapos is wrong. Oh my god.
Aww. There's no pain or eyes.
I'll look that one up, Scott. I'm not sure whether that's one of the ones I've looked at or not. Just from reading it, my eyes are all bugging out right now.
I noticed.
Stop it.
Aww. Her haircut reminds me of Nurse Ratched from One Flew Over the Cuckoo's Nest. You have no idea what I just said, did you?
I do know one Flew Over the Cuckoo's Nest. I can't remember her though. Okay, so audio is all over the place. With this, we're going to have to do some adjustments along the way.
I'll look at her with a pen, paper. She doesn't have the. Does she have the pink handcuffs today? Yeah, she does.
She always does. I don't know why. That must be her particular cuffs. Or maybe that jail just has a bunch of pink cuffs because it's a ladies' jail.
Hopefully they're fuzzy too.
I haven't seen any fuzz.
Be more comfortable.
You want to flip forward for a bit?
Ooh,
Only hands.
kinky. Ooh, look at her wiggling those wiggly wigglies.
Young in chat. It's Young in chat. I just saw Young saying something on Facebook. That's why I wanted to bring it up.
If that's stronger out the state, we inject the state.
Please call raise your right hand to be sworn, please. Please swear to affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed cost to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 2024, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18, 2024 and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those.
I'm going to get that damn rabbit.
Send that to Ms. Barrios. We will ensure
is that what
Ms.
it
Boone
is?
gets
Elmer
a copy of it. State, do you have any position with?
Is that like a how-to pro se guide?
I think so, yeah.
Really? I want to see this. It's like, so you have to go pro se.
So you're going pro se, taking the big step, are you?
Well,
we got some friendly tips for you. Number one, ask if this is Admiralty Court.
Those three motions.
The judge waived your right to a public defender. Well,
sucks to be you, but here's a few tips to make life a little bit easier.
Yeah.
That the court just identified.
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator.
Money guy.
The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for, who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
With regard to the defendant,
And guys, I'm updating the audio real time. It's not a perfect system, but I'm trying to boost different people at different times. So
Okay, and Murph, no, Court TV streamed this
No.
literally just now.
they're
Right,
still
so-
streaming it.
They're actually still streaming it. So we're live streaming it like an hour backwards. So it's not even finished, unfortunately. What they decided to do was hold it back and premiere it tonight, even though it was this morning.
Yeah.
Not sure why.
I'm
Not sure
guessing
why.
because like today there was some big stuff with Young Thug, so they can kind of get some more views on this.
Get better
if they're-
traffic.
Yeah,
Yeah.
which works
so
for
yeah.
us.
Oh, it works for me because I got to
Yes.
sleep.
Yeah, Sarah's nowhere near a microphone, but there's
No.
still ways you can kind of boost certain aspects.
Yeah. So what Dali's doing is he's turning down the judge when the judge speaks because he's quite loud, and then turning her up when she speaks.
Yeah.
So thank you for that, Dali.
And trying to balance out the highs and lows.
Yeah. And just in regard to the
for
discovery,
reservation of
sorry,
proposed costs.
just in regards to the discovery, press. She's going to receive it today. The discovery deadline, I believe, was the 22nd of July. So she's going to receive it. We're going to watch her receiving it today physically. Unbelievable. And we're also going to hear about like how she gets to access it, which is not much. Hey, Steve, how's it going? Yo, peeps. Nah, yeah,
Hey, Steve.
nah.
How you doing? Oh, thank you.
What's that?
Shared it out on X. I need to do
Oh,
that
that's very
too.
much. Yes, you always share our streams on X. We appreciate that.
Yeah.
So I do the same for you. Let's keep going.
Okay.
Hang on. With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor, again, the issue here is, with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to, will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to.
Well, I put to be determined in that motion, Your Honor.
She did actually.
Identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024 and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the courts had the opportunity to review the case law on this issue. There is no constitutional right to stand by counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
Oh!
But your rights for an appellate issue have been
other questions, ma'am, as to the court's rulings
really gone up.
First of all, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some kind of evidentiary hearing.
Evidentiary hearing. Well, Sean said that wouldn't be good for her. So, what happened? Hello?
Can you pause and summarize?
Yeah, okay. So, you put in a motion for standby counsel to be allowed or obviously paid for by the state. And I'm sure, Murph, as you've seen before with pro se defendants, often there'll be a lawyer to the side sitting there, whispering in their ear, giving some guidance and also helping with their written motions. We saw it with Bradley Young. We saw it with
Travis Summers.
Travis Summers. Darryl Brooks didn't have one, did he?
No. That's Wisconsin, though. Those two are, I believe, are both Florida.
Correct. Yes. So it's not unusual to see a pro se defendant with a lawyer helping them. They're not able to get up and speak on their behalf, and then so they're not actually like representing them, but they're there to help the pro se defendant who is still the person who is defending themselves. Yes, Brad, I can't see how this is not an appellate issue. I just don't get it.
You should be bending over backwards to protect the record and to make sure there is no issue here for appeal.
Yeah, and I get that I get that he has no constitutional obligation to provide a standby counsel for her. I get that he's not obliged to. However, having someone advising her helps to ensure that the record is clear throughout the trial.
Yeah.
If she is just representing herself, then she's going to make a mess all over the place. She's going to make incorrect objections. She's going to put forth motions all over the place that are just messy. Whereas a lawyer by her side will help to keep things clear. He or she will help to make sure that everything that she wants to put on the record will be on the record. And that the final outcome of the trial is cleaner. It's just will end up being a cleaner trial.
Yeah.
Surely he would want that. But no, he's acting like a dick. Sorry, he's just acting like a dick. Why is he not doing anything at all to help at this point in time, considering he has just gone to the drastic step of stepping in and overruling or waiving her right to a public defender against her will? Just don't get it. If she waived her right and can't put the standby in charge, there is no reason for it. I think she'll do fine. Give her some credit. She's doing better than I thought. She's doing better than I thought. At this point, this judge basically wants her to try to defend herself from inside of a suitcase. Yeah, he is. Her hands are tied, literally. He's trying to make it as hard as possible for her. It's like this is her sentence. It's like, okay, you did all this stuff wrong and you've been belligerent. You've been hard to deal with. So how about you start paying for it right now, lady?
Yeah.
Right? This shouldn't be her punishment. Her punishment should come later.
Yeah.
This is not where she gets punished.
And it's going to cause the court more hassle, as Jan says.
It is, yes. Since judge determined that Sarah forfeited her right to counsel, granting her standby counsel will give her a chance to at least complete her motions and other court filings correctly. At least everyone has been so concerned with how long this is dragged out and how much hassle she's caused. Why not appoint somebody to make this process simpler? Why not? The judge just made this more complicated, in my opinion. He's just made it more complicated. He's just made this more of a shit show.
No, she never waived her right to counsel, for the record.
She didn't.
The last lawyer just resigned and said, I can't do this anymore. And the judge is like, you're out of lawyers.
Yeah, the judge just made the decision for her because she supposedly was so impossible to work with that he decided, and he's written a 16-page order on this, citing lots of case law, which, like I said earlier, I've had a look at as much of it as I've had time to. Can't really see that much in there that relates directly to her case, but he's decided that she's run out of chances and that she has forfeited her right to a court-appointed attorney. And this thing just has to keep going. And by the way, no continuance. He has made that order, and the dates are the dates, as he says. So now she has to go to trial early October, regardless of the fact that he's told her, no, you don't have a lawyer, you are now pro se. Sink or swim, lady. Just like that. Yeah. So she decided no more dilly-dallying. He decided no more dilly-dallying. The show must go on. Yeah, 100%. And I'm not gonna continue harping about that. I'm more concerned with what happens now at this point. And I just think that this particular ruling is him dicking around. I think he's taking the piss. This is silly. This could have really streamlined the process from here on. And now it's like he wants a shit show. Now he wants a shit show. This is silly. Okay, let's keep going.
Prior to your decision, so I could have had better explained myself and you could have had a better understanding. So by you denying my stand-by counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period.
Thank you.
With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Feretta hearing is regards to competency as opposed to having understanding before you take someone's right away.
Feretta pertains to a criminal defendants seeking to represent themselves. Feretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explaining most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was
You could write a letter.
the Feretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you present.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that is my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from prison break investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21st.
It's going to go up to 3 weeks.
Pre-trial was scheduled for September 24th at 1:30. The court typically
3
has
weeks?
its
Why would they longer?
case managements on that.
I have no 3 weeks.
It was going to be like 4 days. So how did it get out to 3 weeks?
Normal trials are like murder trials are 2 days.
Nah, well,
Normal
I mean,
ones.
I remember which one? Gone blank. The Borowski? No, not Borowski. Bankowitz. When Bankowitz was representing her, and they had a hearing about a year ago, they were talking about how long the trial was going to take, and they said 4 days maximum.
Yeah.
4 days.
Well, that's with a
maximum.
lawyer, but still.
I suppose. Okay, so they're making more time because she's not a lawyer.
Yeah, but not 2 weeks.
3
I mean,
weeks, they said. So, I mean, I'm
Up
sure
to 3
they
weeks.
said jury selection, and jury selection would take longer because it's a well-known case.
It depends. I mean, jury selection can take like a day. I mean, Rittenhouse jury was
Not for
picked in a
this.
day.
Not for this.
Rittenhouse was picked in a day.
I don't know how that's possible. But also, I don't know how Alec Baldwin's jury was picked in a day. That was crazy.
Yeah, I mean, it can. I can see a few days because she's pro se, but the box forts in this trial is going to be lit.
Hey man, you're funny. Okay, yeah, I just don't understand how it's gotten out to 3 weeks.
Yeah.
It's nuts. But anyway, I suppose make all the allowances you need. Go.
Tuesday, due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that Thursday?
Yes, sir. That's Thursday.
Right. Yeah, he really is not budging on
That's
this
acceptable
date.
to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you
You're right.
able to changing that date to September 26th at 9 a.m.?
So an additional 2 days.
Correct.
Yeah, Brad.
You would still have that time to prepare regardless if we have the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case.
On your crazy ass.
Of course.
Okay, all right, so pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed you, but some of it may have been reviewed based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense.
Yeah.
I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court, so it's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. It's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
That's it.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Okay. We're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are they going to use cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cashore would be out there, and our investigator would be out there, and we would record it. The conversations that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code.
We're trying to.
And then we can all file in writing. State these
doing it. Dali, are you able to share the video feed? So go press share and then go from timestamp. So press the share button.
Oh, yeah.
Press the share button and from timestamp. So go share and press a little, no. Press the little, from the little share button. That guy there, please. Thank you. Top. Okay. And then can you put that in private chat, please? Thank you.
Sorry, guys. We're trying to figure this out. And
yeah, cool.
Hell is going to take over.
And action. Yes, I'm going to take this over. Thank you. Lovely. Share this tab instead. Oh, done. And go. There we go. Right from exactly the right point. And putting the sound on. Thank you. And I'm just going to fix up.
And or her or his investigator would come out either to the sheriff's office.
My sound. Sorry, guys. Let me sec.
And they come and view it, but it's done in the presence of the state. It's done in presence of law enforcement. It's done in presence of the CSI for the chain of custody.
Sorry to interrupt everything.
Attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different.
It's a secret, Tenny.
Doing it in the witness stand or wherever.
We couldn't work out what timestamp we were at because it was live streaming.
That's the most appropriate.
It's really annoying.
So that's why we had to do that.
Review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified.
Oh, nice. I tried earlier.
Yeah.
I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court. Due to the sensitive
How are
nature
you?
of what may be being
We are a
discussed
bit
or
crazy.
viewed,
Well,
I need to
yeah, there is that.
prevent media access.
Welcome.
So
Very
without
glad
doing
to
a
have
little
you
bit
here.
more further dive or research in that, I don't know if I can make that call at this time.
We like a laugh around here.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So, if you could please look into that, 'cause I disagree with the.
Actually, a good idea.
involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidentiary. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time,
Sorry, what day
in the
did you say?
USB drive or the
I'm not sure, but there's some
after
hearings
our
coming
viewing
up
here in
soon.
the court stays at your position
not
to
in
then
camera.
have that
Oh, did you say that?
meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically.
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're trying to do that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again,
Don't talk to the cops.
those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of.
Geez, I wonder what they're going to use.
irrelevant photographs.
Anyone want to take a guess what digital evidence they might use?
I believe the videos are too hard to decide which ones to use. And I don't know that there's a whole lot of evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
what I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion we had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know, and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that.
Well, let's just see. Digital evidence. 1 2-minute video of her boyfriend in a suitcase going, Sarah, can't breathe. That's it. Pretty much it. Can't really think of much else. Oh, there might be some autopsy photos and things like that. But pretty much the 2-minute video, you've seen it already, Sarah. We've all seen it. Yeah, that's about it. Don't need much else. Yeah. Kat, wasn't Alec Baldwin's evidentiary stuff literally televised? That'd be a good question for Dali. Actually, he's the expert on Alec Baldwin around here. Evidentiary hearings, I mean, we have one for the potential retrial of Murdoch. But, I mean, I don't know whether or not I'm giving away a spoiler if I've watched a little bit further ahead than you guys, or if I've missed it. But the court was saying that you can't put all the evidence out in front of the public because evidence needs to be released at trial. Now, that's not really true because we see a lot of evidence before trial. But maybe there's stuff that's under seal. Who knows? Who knows? But we've seen the big evidence. We all know that. Everyone's already judged. I just wanted to say also, Mavka, I like this comment. I've come full circle and think Sarah seems like a fun lady and I like her. Can only see manslaughter charges, not murder. Look, I don't know. I feel like I could handle Sarah in very small doses. If I had to hang out with her for more than about 3 minutes, I probably would be just as frustrated with her as everybody else. I don't think she's that bad. I don't think she's as bad as everyone's making out. I feel like she's mellowed since giving up alcohol. I do really feel her frustration at being stuck in this dormitory and having, obviously she's brought on herself, but being in this dormitory and having these public defenders who she's asking questions of, they're not getting back to her, and she's inquisitive. She's the kind of person who likes to be involved. That's just her nature. And for her, she's like, well, why aren't you speaking to me? This is my life on the line here, guys. She thinks it's not intentional, therefore it should be manslaughter, and she's been charged with second-degree murder. She wants someone to help bring her charges down to manslaughter. She doesn't understand why they won't talk to her about that. So for her, it's really, really frustrating. So I like to try and see things from other people's points of view. I like to try and put myself in their shoes. That's just me. That's my nature. And yeah, if that's how she feels, I try to sort of put myself there. And yeah, I think, Marco, you've kind of done the same thing. You've sort of looked at her and gone, maybe she ain't so bad, and maybe it is kind of manslaughter, but yeah, I mean, I certainly don't defend her actions. She shouldn't have done that. Like, that was terrible. Yeah. Anyway, I think her frustration is with not getting her way. It just so happens that aligning with a situation that seems unfair. Yeah. I mean, people always see things through their own lens. Amen. They always see things through their own lens. So you can't stop people from doing that. What I try to do is take myself out of it and put myself in their shoes and go, okay, so if I were them, how would I see it? Why are they acting this way? And sometimes my empathetic side comes out a little bit too much, and I'm like, I feel their pain. Like, I can feel why they are behaving like that. I understand why everyone else is so mad at them, but I also feel why they're so frustrated. And there are some things that are happening to them that aren't right. So two things can be the same at once, right? So two things can be true at once. She can be guilty and she can be a terrible person for doing all these things, but also there can be things that are being spread about her that are incorrect. There can be things that are being done to her that aren't quite right. I don't think an average adult the day before the death would honestly believe that a dude would die from lack of air in a cloth suitcase. Well, that's what Dali has said. He was like, I actually wouldn't think someone would die if you put them into that suitcase. I think that I would think they would die if you didn't take them out of there. But then again, she fell asleep. Yeah. Anyway, you have an awesome skill doing that. And I also always respect your point of view and your interpretation of our Constitution. Oh, thank you, John. Thank you, John. I do actually, I get a lot of heat for it though. And the Young Thug evidentiary hearings are also televised. Oh, Kat was so sweet. Thank you. 3 minutes and you'd suitcase yourself. All right, let's get back to it. Oh, there was a question actually, Dali. What's the evidentiary hearing for Alec Baldwin televised? You're muted.
Whoops. Yeah, that was on day 3 and that was televised.
Okay. All right. Because, yeah, the judge seems to be saying that, evidentiary hearing shouldn't be televised because there's all this stuff that shouldn't be allowed out to the public. So,
no.
Referring to this case.
Every judge is different.
Yeah. Okay.
Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable when you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released.
What?
From
Really? Released?
So
What are they? Ellie, we get them.
I
You just said her telephone calls have been released.
The jail. I know that Mr. Lane and I previously had worked on the laptop with USB drives that he had furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable that there was a process or a procedure. I don't know who your names are from the jail. I do know the captain whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
Okay.
For which?
The captain that you spoke to. Who was it?
Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail tell me something different.
Who?
There's,
What are their names?
there's multiple sergeants.
What are their names?
I'd rather not get involved with fear of harassment or anything from.
Oh, wow.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically
Yes.
as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service.
What is
And it was
this
provided by
issue
US Mail.
between
It was sent out last week.
the jail and these
I haven't
sergeants?
received anything such as.
Don't worry, I have a
Before-
copy to give to you this morning, just in case you
And
have
her
not
getting a
received it.
laptop? What is
Yes,
the
last
big
thing I
deal?
have is your order that you provided me with, the implementation of your USB drive.
Okay.
option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by US Mail.
by US Mail?
Mhm.
Yes. I actually have 3 motions, please, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. There
How
was
is
simply
the
a
mail
clerical
address
error,
wrong
and
for
that
her?
has been remedied.
She's a courtroom.
But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available
We'll just
for
give
your
it
use.
straight to the jail and
So if I
Have them
see
provide
that
to her
my
daily.
evidence is digital, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail, so by me trying to get a hold of
If
the
only.
captain nonetheless, it's going to be a feat in itself. So I want you to know if anything that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So
Right, John.
I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday,
Malcolm.
September the 3rd at 9 a.m., we'll have a hearing to review the physical
You're
evidence.
right.
At that time, the state will provide its exhibit list.
Brilliant. That is awesome. Sarah should file a motion to restrict the judge and prosecution to only be allowed to work on her case 8 a.m. to 4 p.m. She should file a motion for them to only be able to work on anything from 8 a.m. to 4 p.m. Ever. And they should only be allowed to have access to a laptop with no internet and no cord.
That's actually a good idea.
Mm-hmm.
At least put that on record, like shove their face in it.
Yeah. Of course, the entire world would be like, oh, she's so rude, she's so this, she's so that.
Screw it.
Screw it, everyone thinks that already anyway.
I wouldn't be surprised, John, if they forget to plug it in. Unity and all.
100%.
And even if they do plug it in, it's I'm sure a crappy government old laptop, so it's only going to last 2, maybe 3 hours at most.
It won't last 40 minutes, for goodness sake.
If
And
that,
what's the
yeah.
point of it? Like, it probably won't, it won't have internet.
No.
Right? So good luck. Like, she is going to be filing motions. She needs to be able to look up case law. Right?
She
So
has a library for that.
She has a library for that.
Yeah, legal
All right.
library.
So 8 a.m. to 4 p.m. So she has to look up her case law at, really, she needs to use other times for that. Right. So
Assuming the library's open then, which it probably isn't.
assuming she can. And from what we've heard from Chile, which I'm sure that it's not very different circumstances, they don't have much time to be able to just do as they wish and read books. Right. They don't have access. The lights are off. Whatever. So it's not like you can just do as you please and just read whatever you like and write things down and have access to pens and paper and stuff like that. So she's completely tied. Like, I just feel like this is the judge making her pay for everything that's happened so far. Her punishment is going to be whatever the sentence is for her crime. He shouldn't be being punished now. This is stupid. He should be making it as easy as possible from here on. He's already handed down his order, which is waiving her right to a public defender. Fine, if we just accept that. Come on, do something to make this a little bit more streamlined. And can he not acknowledge that there's no way that the jail is going to make this any easier? What she's trying to say here, and she's actually saying it flat out, is that the prison guards, they're likely to leak information, steal her discovery. Probably people in the jail are going to steal her discovery. They're not going to make it easier for her at all. She doesn't trust anyone to hold this stuff. I don't blame her. Apparently, the judge complained that you're making her work too long. Yeah, David Nelson.
I'm writing a records request right now for Sarah Boone's jail phone calls and stuff. It is hit and miss if I'll get it. But they also, when I type stuff in, they put up like other suggestions of agencies to contact.
Oh, really?
One of them was, it says, if you are looking for records or services pertaining to animal control or services, please refer to this website.
Animal control?
Yes.
All right, let's keep going. Might speed it up a little bit.
Which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
You can caveat in that order being, unless it hasn't already been done. In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3rd. But the in-court physical examination will be at September 3rd. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document.
Yes, just on that, Benjamin, I know that the jail is a separate agency run by the sheriff's office. Again, another reason why he should have allowed the standby counsel, right? Another reason why he should have allowed the standby counsel, right? Streamline this process, make it easier, not harder. Dear me.
So that it identifies when that meeting took place, when the evidence viewing took place.
Understood.
Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to these state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections, and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself, to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-Y. Don't get asked with that one.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes. Please.
Then you can do that. Like I said, Mr. J, if you could follow that notice, just to identify when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going to possibly working on it for the laptop. I do not have my discovery as of yet, and I do not have a laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptops in quotes closed for the day at 4 p.m., I can therefore pick up using the hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and I'm trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by reading that topic, I have that to also be looked over.
Okay.
Please. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And I will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I'm very weird at saying these type of deadlines.
Well, we're setting them today,
I understand. So the 3rd is what day? Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September
The
26th is
dates are
the
what
trial case
the
management
dates
date.
are.
October
You need to
7th
get a
is
t-shirt
the
that
trial.
says that.
So by me not even seeing my discovery yet 2 days and only being restricted to a laptop from age 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Fuck.
Oh,
I'm
well,
sorry,
thank you.
but fuck. I'm sorry, but fuck you.
Wow. So, and over
Oh, you have
4 years, it comes
62
down
days
that
to
I
prepare
think
for
I'm
trial, not
62 days.
including today.
I'm not going to answer that question.
Sorry, what was the question? Ellie was voting out.
I'm sorry.
What now we're
Right.
addressing, ma'am, is September 17th,
Suffer,
not including
Sarah.
today. And you're going to get your discovery
more.
today.
That's it.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
Yeah, that's it.
I'm not going to answer that question.
Well, she has a freaking point.
He has a point.
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence.
You're a dick.
It sounds like
That's
Mr. J is going to try
right.
to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks.
Now, I
at
bet,
minimum,
like, there
or
are
2 weeks at most, rather, to
20,000
lodging objections to the
ones
physical
out there
evidence.
going, here's the best fit
I
for you.
just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I
No,
can
that's
tell
not
you
legal
is that if you
advice.
have
That's just
objections
freaking-
to any of
That's just.
Okay, what she said, Young, was so after 4 years, it comes down to this. I have 62 days to prepare my own case for trial. And he said, I'm not going to answer that question.
Sarah. Maybe Sarah has laid enough of a record for this issue, but she really needs to write a motion to delay trial.
I don't understand why she has not come forth prior to today with a motion for continuance. He'll deny it anyway.
I'm sure he
Like,
will,
clearly.
but she really needs to lay the groundwork.
I don't understand why she hasn't. Like, she's bothered to put forth the other motions for today.
And she did a good job, a great job.
She did a pretty good job.
All
But
things
why?
considered.
Why has there not been a motion for continuance
God, I'm
to
like
discuss today? I
borderline
don't
about
get
to
it.
write her to tell her to do this.
Yeah, I don't understand. Like, she's asked, like, she's verbally asked, but she hasn't put it into a motion. And I was super impressed by the
Yeah.
fact that she worked out how to do a motion.
Yeah. And like, I mean, her lawyers, her letter, she really spurred out and just ranted. But then when it came time to do the motion, she did a fantastic job.
She did. She really did. And I've had a few people in my comments say, like, surprised by how well she did.
Yeah.
I had,
Like
a
it was
couple of
night and day.
paralegals and even a lawyer come and say, wow, actually.
I mean, it was a
I've
little
seen
wordy.
Nick Darrow said, I've seen lawyers do worse.
Yeah. I mean, it was a
Yeah.
little wordy, but
Yeah.
she made sure to get her point. And okay, she only really has 20 days to prepare. She can only prepare a third of a day.
Third of the day. Yeah, you're absolutely right, Mavco. You're absolutely right. This is ridiculous.
I really hope this judge gets just railroaded on appeal, but
the exhibits that the state may seek to move into evidence. You will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay, and if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yea or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you've delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
Nudge,
I wouldn't
nudge.
necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else if they just delegated the date and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it.
So the judge is really giving her a little bit
I
of a
can't answer
hint
that
now.
question again. That would be me providing.
He's saying you
advice
haven't
as to
told
what
me.
to do if something
Yeah.
happens. I simply cannot answer that question.
He's giving her a hint. He's saying you need to tell me properly. Like you have to.
Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than
I really feel like maybe he is trying to like hint, do it right.
I'm guessing I agree with
Do it right.
Come on, sweetie, you can
Now,
do
ma'am,
it.
I believe that takes care of all of the
Come on, it
deadlines
starts with a C.
regard to the state's
Come on.
Come on.
exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be
Inuits?
seeking.
Not constipation.
I am mindful.
No,
that you will
no.
be receiving the discovery today.
Not
and
incontinent,
that,
no.
You have not had the opportunity to review.
You're
some
not
of the
Amber Heard.
items that may be
Man,
in the discovery. So how much time would you like to provide to the court
we
The
know,
list
Jagra.
of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses. And then also.
You're just a big
try to
meanie, number
communicate
two.
with them On a payphone only.
You have no sympathy for
However, I
anybody.
do not have regular access
Big
to,
meanie.
and I'm limited to only 15 minutes that I have to share with.
But I'm supposed to still like you because you gave me 20 memberships yesterday.
That is a hurdle.
So,
Please
fine.
take
It goes a long ways.
It does. It lasts a bit.
We're whores. I was gonna say.
Yeah.
To determine any expert witnesses. May I ask, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Who is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
I will say she is taking this seriously.
Shit.
Give us 1 second.
Please, and also because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me
Please
a copy
send
also?
stuff to the wrong address.
The protocol, ma'am, that was what was most recently sent.
To her?
I don't know.
Yes.
Whatever it is, the last thing that I received from you and the court was the hand delivery of the order.
They got her address wrong.
I have a copy that Madam Clerk already printed out of the protocol.
Jailhouse.
We will have the deputy hand deliver that to you right after. What I do?
What the hell?
Oh, I sent it to Anita. That's why. Give me a second.
She had to
I'll have
file a
Madam Clerk
motion
print that out for you
to
right now.
fix the address.
So, understanding that as of right now, you do not have hard copies.
This is
You'll
a
be provided
circus.
digital copies. And to review all this evidence, ma'am,
And yet
when
people think more government is the answer.
in time,
Yeah.
do you feel comfortable in providing the court
They can't even send
and the
mail
state
to
list of
her.
your witnesses
We
and
know
what
where she
you may be
is.
seeking to introduce?
She's not going anywhere.
I'm going to go to be determined because
There's not.
I explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to
Sarah
Fucking
in
post
jail.
office.
Yes.
God damn.
I don't have a phone book. There's no way.
Get a goddamn-
I know how to
Mail-
do
no matter the
anything without
Rain nor snow nor
and,
sleet.
um,
Oh, we might get the wrong prison.
equipment In order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I will be able to do any of that at this moment. I would like you to propose your understanding of.
This is the first pro se
I'd like to have with the captain, so I can see
we've ever
if I
seen that
can have access to a regular phone.
Isn't
doesn't have
crazy
access to
that
internet.
want
Right now,
does
I
not
have a
want to be
tablet
pro
that
se.
is used for
She doesn't want to be
text
per se.
messaging
Yeah,
and
you're actually right.
movies and the law library that I utilize.
I mean,
I
Ty
don't have access
wanted to
the
go
phone,
I
pro
wanted to
access
se,
be.
to the internet.
You can certainly have
and
those
then Jill Brooks
conversations
was
with
insane.
the jail representatives. But ma'am, we were on notice today
This
to
is
address those deadlines,
bizarre.
and I cannot set a to-be-determined deadline at this time. I understand that there's been some delays with regard to the discovery, as I told you at the last hearing. We're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
Suffer, babu, suffer.
If the defendant's not going to make a suggestion, they state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to use at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her. Would be our suggestion.
Okay. Ma'am, are you amenable to that? 14 days after you've had the opportunity to review the digital evidence, and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable saying this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards.
Ooh, she's really eyeballing the state there.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Oh. Hint, hint.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now. Since you are
Disclose,
aware,
Sarah.
and
Come on.
why for good cause, I'm stating my good causes now, if not there are additional at that time.
Good cause.
Ma'am, as of right now, the court is inclined to agree
It's a
with the
C
state's
word.
suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd. Sounds like it'll take place way in advance of that. You were to provide in writing your list of
September
exhibits
3rd?
that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown.
Good cause, maybe.
State, would you like
She's
the opportunity
the
to
good causes.
review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical
We
evidence.
can't tell her to file a continuance because that's legal
Okay, all
required.
right. I will set a deadline for the review of September 26th.
What's the C word? She's looking for wrong answers only.
For my executive witness list.
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right, so the deadline for the state's
Well, she
production
only
of
has
witness list
8 hours a
will be
day.
September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 7th.
Calendar.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around
Gosh,
with my
no.
scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections.
Coast.
Anything
No.
else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts.
Linda.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here.
Oh, Mr.
All right,
Casey's
very good.
coming.
Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in.
What's the caps? What's the caps they can?
You can stay at the
What's
podium,
that?
sir. No, just the podium, Sergeant. If
Jillian,
you could raise your right hand, Madam Clerk's
Jillian,
going to
is
go
it
ahead and
the
swear you in.
one? Hey, Paige.
All right, sir, good morning. Could you state your name for the record?
Sergeant Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown court holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right.
Oh,
Have
here
you
we
had the
go.
opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir?
Let's go. Come on, you gonna let her have her laptop? I wonder whether he's even one of the ones that she deals with regularly.
Sir, good morning. Can you raise your right hand? Madam Clerk's going to swear you in.
You swear over the testimony you speak shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Billy Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir.
Mark,
last time I
how's it
saw you,
going? Keep it together,
I
lads,
tasked you with digitizing 2 bankers' boxes of information, and you said that you would endeavor to accomplish that task by today, understanding that you were out of town
Yes,
for your
ma'am.
son's wedding. Hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from the Boone for the court's needs if they wish to facilitate that through the, it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you could please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol to
Oh, sorry.
have those added to the laptop. It'd be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you.
I'll keep going now.
Mr. Lane, you took custody with you, sir, as well. Well,
Okay.
before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his
Jump drive.
compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain DiGiovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll form.
Please, in regards to the laptop.
Okay.
Thank you.
Oh,
Thank you very
okay.
much, sir.
Organize
Mr.
a
Lane,
meeting
we
with
last year, you also had
whoever
2 bankers boxes. Did you
is
bring those back
jail.
with you, sir? Okay, could you bring those back up?
Yeah, right. We'll see if that happens. All right. I just want to address something. Okay, so the reason we're perturbed, we're moving past the whole thing about the judge overriding her right to a court-appointed attorney. I've had my big rant about that over the last few days. If you want to hear why I'm grumpy about that, there's streams on that, and I've fought people in the comments about it. But no, at this point in time, this particular hearing, she's been forced to go pro se. She does not want to be pro se. She wants a lawyer, but apparently she can't get along with the lawyers. Fine, okay. She's now got how long? 2 months? Less
Yeah.
than 2 months?
No, 62 whole days. Hello.
62 days. Oh, sorry, 62 days to prepare for her trial. Today, she's finally receiving the discovery. The discovery deadline was the 22nd of July, by the way. Right? So she's finally receiving the discovery. Now, Paige, you said she's had plenty of time to prepare. No, not as a pro se defendant. She's been told that she's going to be a pro se defendant, and she's just receiving the discovery. And all of this talk that's just been going on is about how she's going to actually access it in the jail. Remember that she's in a jail. She's in like an open plan dormitory, right? So she has no privacy. She has nowhere to work. She has no access to the physical discovery. So these boxes that are being brought in, they're not going to be given to her, right? So they're going to be taken away, and she has access to some, what do you call them, jump drives, USB drives, and a laptop that won't have a cord. So they are supposedly, the jail staff are going to charge up the laptop. Let's hope they do. And she's going to have access to it from 8 a.m. to 4 p.m. weekdays only. Don't know how good this laptop's going to be. Let's hope it keeps its charge. She's not going to have any internet access, no proper phone. Who knows how she's going to be able to research, look up case law, things like that, old books from the library.
Yeah.
And the only way she can have contact with the court is via snail mail, which has a very long delay. Like it takes 3 or 4 days for the court to even receive her mail. So she's quite stunted in being able to represent herself, and she doesn't even want to represent herself. So I feel like what's happening here is the court is punishing her for supposedly being so hard to work with for the last few years. And no, she hasn't got enough time to be ready for beginning of October trial day, now that she has to prepare herself. So her Sixth Amendment right to a fair trial, I don't believe is being upheld. I think it's being violated. I don't like it. Just don't like it. So that's why. Ella, slow down, keep watching. Okay. One last word, chicken. You want to jump off?
Yeah. It's been
cool.
fun. I'll be in chat, and I have to go vacuum. So later, guys.
Okay, bye. Gotta go vacuum. All right, let's go.
Leave studio. Do not end stream.
I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with the Apple jail?
It's going to be my intent to try to get out there in a week or beginning of next week.
Thank you.
What's going on? What's going on?
The original, the 5,500, or just we would increasing 5,000 to 10,000?
Yeah, 5,000 to 10,000, I think it makes sense, Your Honor, just because it sounds like that we may, based on what's already been done, Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
I wouldn't go that far.
One thing I'll add, Your Honor,
go.
is we would have to come back and file another motion, is
You're right.
if JAC would agree to travel expenses in out of county. If not, I can get that in some form of a writing and get it to you or to the JAC. That's
Mr. Lane, Your Honor, we'd have no problem with the court authorizing, say, $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need a word for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will have the order submitted.
All right, very good. Just send it to Ms. Berrio, so I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Oh, Mr. Lake, thank you so much, sir. All right.
Hi, Mr. Lane.
Yes, ma'am.
What is his name?
That's Christian Lake. He is an attorney associated
Lake?
with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than
Hang
what
on.
you've already addressed this morning?
We watched this bit.
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be
Oh, no,
there
we didn't.
for
He's just asking
the
again.
digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of like a.
You will be there.
Oh, no, hang on.
You will be there.
Can we
Mr.
see
J is
this
going to be
bit?
recording the conversation.
Did it flip backwards?
With regards to another document, proposing the dates for today's hearing. And I guess it's some type of notice. That's what please that she was going to print out to give to me, so I have that.
Okay. Mary,
I did not receive that, nor did I agree to this protocol list.
as to everything that's being discussed. Can you print it? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a
Oh,
moment.
here we go.
Thank you.
Okay, we moved on from scheduling and we're doing motions. More motions. In fact, He's already addressed the motion about the Stand-by Counsel, which may be grumpy. Let's see what else. He did click backwards, didn't it? And that was that little thing on the flip on the screen. Baron Huckleman authorizing 10K for her investigation. Yeah, I saw that. Baron was like, oh, he should have 10K. Well, sure. Like, you can be my boss.
Ma'am, with regard to one of your motions, the motion for defendant's immediate address correction, as
Address
identified
correct.
earlier, there was a clerical error using the general PO box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
Seriously. Really? They had the PO box. Wow. Bureaucracy. Yeah, scanning court documents onto a USB. They really need an investigator for that. Couldn't they just like hire a temp, like some teenager? Yeah, it would be funny if he denied the mail motion. It's like, yeah, because I'm in a bad mood today, I'm gonna deny that motion. Denied.
Mr. J, if you want to approach sir to review the hand-delivered motions, it is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. The second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, (A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, counselor. Just let me know when you're ready to address them.
I have a motion for
Your Honor,
continuance.
the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Whoever
Okay,
and
I appreciate
whoever.
that, sir. Ma'am, with regard to your request for discovery, the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in a female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, in my understanding, in communications with the captain, to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now, or are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I never,
You have written letters, ma'am, specifically asking for a laptop,
do you know what the date of that is?
without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom of movement, well, I'll notice the sheriff. We'll try to set that up for this week so that it can be done expeditiously.
Okay,
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you.
Don't say
When
no.
you do not have a place to store it, the jail does not have a place to store it.
we have an entire property department for all of the inmates on the entire compound. I've been given permission also by sergeants,
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can
Really
store
should have come
additional
forth with letters from
case
them or
documents
something.
at my bunk. help me understand, please, for future reference, so I know how to approach. By my statements that I made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited, restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letter from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag, or property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's
No nefariousness.
I want you to have this information.
Oh,
and as I
do you?
addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it.
No
We had to
one
use your
wants to see
investigator
what's
to do
in
that.
those boxes.
And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
Yeah, they just don't
My
care.
opinion differs. I was never asked anything, just like my
Begs
letter
differ.
to you prior to you forfeiting my right to counsel. I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain
on vacation.
Di Giovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain it, or a tennis motion to have it released from evidence. The concern as,
What's a tennis
hey,
motion?
Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. But we had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to
I'll see,
figure out how to get those
okay.
2 bankers' boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those 2 bankers' boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
Actually, I'm just trying to find a solution. So
Same.
if she moves Corey Tennis to release those 2 exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
So if she wants to do ori tennis, which means oral motion,
Oral motion.
to release those two exhibits, the state has no objection. And it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I want to ask her, but perhaps the court can answer that question.
Ma'am, the state has recommended a position for in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the cabinet member, he can release them to me?
Granted.
No objection to her.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those bankers boxes.
That was simple.
I will have Ms. Berrios coordinate a hearing for the 13th at 8:45.
See, okay, so a tennis motion is an oral motion in court, right? Okay, so they know she's a pro se defendant. Why can't they just say that? Why do they have to use legalese in front of a pro se defendant? I suppose that they don't have to make concessions for her, but it would be nice, considering she doesn't even want to be a pro se defendant. Dear me. And like also considering that she doesn't know even how to make motions, or she shouldn't know how to make motions. She's done pretty well making written motions so far, but it'd be good for her to know that she can make oral motions in court. And she just did one, didn't she? Like it was granted. Wow. The state is buttering her up for a plea. You think, Benjamin? I think if they were going to offer a plea, they would have done so long ago. Or had they? Did they offer a plea, like a murder charge plea? Angry they had to go to law school and pay money to do this. The state just helped her out. Just then they did, yeah. The state did. I'm feeling that the state is actually getting a bit tired of all this messing about. At this point, I think they are.
Well, we cannot do it the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on
plea negotiations.
Wednesday, August 14th at 1:30, if we need to address
I know
the jail's
but we end up finding out about them.
position in taking
Benjamin.
hard copies if Mr. Lane's unable to have it delivered. And Mr. Lane, you advised earlier when Ms. Boone inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What was
Ouch
the
with your
hearing
boxes.
for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop,
Yes.
we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. Maybe not be necessary. We're going to go ahead and set it. If we need it, if we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to you today.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
Oh, we're going to have a hearing on Friday.
You want to go step in, please?
That's the 9th now.
Okay. Reasonable freedom.
Okay.
Right.
Ms. Meredith will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, just please, 1 moment.
Uh-huh.
What was the conclusion for the sensitive issues?
Yes, nothing, no handcuffs in court, right, so wait.
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That's deadline is set for September 3rd at 9 a.m. We'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided, the names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, represent yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence, that I might be able to utilize that?
So my understanding is there was an imaging done on your phone with software called Celebrite, and that
Celery Bright.
discovery that has been provided to you. If
We
you are
can't
talking
trust
about
Celery
a
Bright.
physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person you hired. I know that defense attorneys in this area hire somebody named Richard Connor, Connor, and then that will be between you and the AAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him with us being present and wanting to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, a legal expert that can give me a near download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
If it's not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline, but there is additional data there.
bet she's
You will
got
make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence, because like you said, there's so much of it that will be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going
No,
to make sure
you wouldn't
that's
have.
there.
Just as clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you, and to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior, so this would be a milestone, an epic milestone for me to be able to finally do that.
And like from her perspective, this is probably why she feels frustrated with her lawyers. Like she thinks that she should have seen all this stuff, right? Now her lawyers are probably like, well, no, I look at the discovery and your job is to sit in jail and let me do my job. So she just doesn't understand that she doesn't just get given all this data to look through at her leisure. That's not how it works. So, and now that she's pro se, and the state's actually asking her, oh, have you received this stuff? You would have received this stuff. And she's like, no, none of it's been supplied to me. And I gotta say, she's actually behaving herself today. She's being very respectful today. You got to admit, guys, like she's not being nasty today at all. She's not being passive aggressive or anything like that. She's definitely behaving. Yeah, today she's like, well, right now she's like, well, no, I haven't received any of that. Of course you've received none of that. It went to your previous lawyers. And I bet you underneath that veneer, she's like, well, God damn those lawyers, they never showed me that stuff. Of course, they're so incompetent. Yeah. The first thing she's going to check is YouTube. Well, when though? She's not going to have access to the internet. She wants to check in on her Farmville farm. But if they give her the phone, they're not going to give her access to the internet. No way. All right.
So now if I don't have what I need or I'm looking for, how do I go about, I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy mirror download of my phone. And it could be brought to you for physical, but they are physical.
So again, that's going to be something that requires an expert. And then if we get a defense expert, and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you all are supplying?
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to, is the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program. And all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before. Just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence of you viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
okay.
It needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of its phone.
Thank you very much.
Ma'am, do you have any other questions?
Okay, so everyone is aware that I'm in the process of trying to talk to the captain.
Who?
And okay. Your Honor?
Yes, ma'am.
I believe I am okay right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access, where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I'm writing you a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it's uploaded to the clerk's website.
That's a fair question.
You actually know something, because you've already had my address correction, but I don't believe I've updated.
Well, it's been updated now.
Not me on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or portal or whatever it is I might be attached to in order to receive notices to be part of the hearing?
Notices have been sent, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
I'm grateful. Thank you.
Yes, ma'am. Thank you.
All right, we have a poll up. Oops, go away.
For Zoom.
Okay. Do you think that Sarah will get access to the internet? Hell no, or maybe. I'm not putting yes on there because I think yes is just a little bit too wishful. I think that's a bit too wishful there. So nah. What do you reckon, guys? What do you reckon? Hell no, or maybe. Hell no, or maybe. Didn't the judge say she would have internet? The judge can't be, the judge can't say for sure she'll have internet because he doesn't run the jail. He doesn't run the jail. So he said if she has internet, then she can, he was talking about whether or not she can email him if she has internet. If she has internet, he has no problem with her having access to internet if the jail allows it. And if she has internet, then she can't contact him directly, but she can contact his judicial assistant. Fantastic. So it would be awesome if she had internet. Wouldn't it be amazing? I do wonder though what she would actually have access to. So I don't know whether she'd have access to YouTube. Wouldn't it be funny if she did? She could get in chat. Wouldn't that be fun if Sarah turned up in chat? The real Sarah. The real Sarah. But she really needs to be getting on with her job, which is being her own lawyer now. Hell no, or maybe. We have 38% for hell no, 62% for maybe. I think I'm gonna cast my own vote, or can I? I probably can't. Yeah, I'm going for hell no. I'm going for hell no, because I think that from what she's saying, and I believe her, I reckon she's got no reason to make this shit up. I don't think that the jail is doing her any favors. I don't think they're trying at all to help her get ready for her own trial. I think that's the last thing that they care about. Getting a room for her to do her research, to have access to a laptop, to her discovery, making space for her to write her motions. I just don't think they care. Like, I think like Benjamin said, was it or Brad, they don't have any interest in protecting her right to a fair trial at all. That's not their job. So I just don't think they care. And especially if somebody in the jail, or more than one person, has been involved in linking her jail calls. Yeah, I don't think. They offered her a storage space. Well, yeah, you're right. That's nice of them. But yeah, I mean, who was that? It doesn't mean that there aren't some guards who are obstructing her from preparing. So it's not like she's in a particularly great spot to prepare for trial. And yeah, 62 days, not counting today. So, and what do we work out that it actually is in terms of days that she'll have access to a laptop and her discovery? 20 or something? It's not good. Yeah, of course we all want to hear the jail calls. Of course we want to hear the jail calls. We're trying. Yeah, Dolly's trying. Dolly's trying. They can't let her stay in a hotel or conference room. She's near. Oh, I know. Like, and this is why it's so difficult. Like, we can't ask for the impossible. But then again, what can we get? Like, what can we hope for her? I think some basic internet access, definitely we could ask for that. We could hope that that laptop is properly charged, because I have a feeling that she's not going to have access to that laptop all day, every day, like we hope. I would think that she could have that paper discovery at least throughout the day. A proper phone, even if it is monitored. Should it be monitored though? Because she's her own attorney now, so that's attorney-client privilege, kind of, isn't it? Yeah, just the basic necessities that she would need to prepare for her own trial. So no, not a hotel, but whatever allowances need to be made for her to be able to prepare. And yes, this freedom of movement thing that we're going to see on Friday being discussed in this hearing. Yeah, she's going to need to be unfettered to be able to work, and in the courtroom. The bare necessities. Yes, the bare. I just feel like she's being punished in advance of her actual sentence. Like, it's punishment enough that she has to go pro se. Now, why make it even harder? I have a feeling that she's going to overstep her internet phone boundaries. Yes, but she hasn't yet. Right? So I'm getting a lot of this, and this is not aimed at you, Ronnie, at all. I'm feeling a lot from the comments that I've seen, and the people who are streaming about this, etc., that people are making judgments about what her next step's going to be based on what they perceive that her previous steps have been. So they've gone, oh, well, she's just going to take a standby counsel and use them as her lawyer. She's just going to take a standby counsel and she's going to abuse them, right? But she hasn't yet. So therefore, do you just not give her that grace? Do you just assume she's just going to overstep her boundaries with the phone? She's just going to do this or that. Well, you know what she did today in court? She behaved herself perfectly. Like, she took notes. She was courteous. She was kind. She didn't do any... I couldn't fault her today. Can anyone fault her today? At all? I couldn't. I thought she did very well in court today. The only thing I really wish she'd done today was put forth an oral motion for a continuance. Damn it. Damn it, Sarah. So, I mean, maybe she's learned a lesson. I don't know. Like I said earlier, I like to put myself in other people's shoes and just try and understand what it is that they're thinking. And sometimes I end up getting myself in trouble for that. But I don't defend her actions. I don't defend what she did to George. I don't defend any of that. I think this could be a manslaughter case, not a murder too. But we'll never know, because she's going to go down for murder too. No question, because she's not going to get a fair trial. She's not going to have someone defending her to potentially get a lesser charge at all. No way. We're not going to hear her side of the story in any coherent fashion whatsoever. Not going to happen. Nope. Because the whole world's already judged her already, and the state has unlimited resources. She's got none. She acts normal, except for the stuffing her husband in a suitcase. Yeah, I know. Other than not knowing the magic words, can't fault her, no BS, soft sit arguments. No, today she was very good. She was very good. The murder 2 charge is stupid. Yes, I think the murder 2 charge is stupid. I think she didn't know what was going to happen, personally. I think the battered spouse thing is not a good defense. Don't get me wrong there. I think that's a silly defense because it wasn't self-defense. It wasn't self-defense. Yeah. Yeah, absolutely. So a good attorney, I believe, could get this down to a manslaughter charge. But no, not going to happen. Not going to happen. She's not going to have a fair trial. It's as simple as that. It's as simple as that. Yeah. Cool. Okay. Thank you, everybody, for watching this with me. I appreciate it. And thank you for understanding where I'm coming from, my point of view, and just supporting my channel. And Dali and I also, like, thank you, Dali, for being here with me and like sticking around, and justice for Sarah Boone, just justice in general. Thank you for sticking up for justice, sticking up for due process. I appreciate it. I think you're all great. USA, USA. And in Australia, we have the same kind of thing. We have due process. Innocent till proven guilty. It matters that the process works. We don't have the process, then we have nothing. We have nothing. And you know what? If this doesn't work out, she might have to just go to trial again. Ha! Although I doubt it. I don't think anyone's going to have, I don't think an appeal is going to work out for her. Probably they'll just say, you know what, it would have worked out the same way anyway. Harmless error. But there could be some appellate issues there. Bobbing with Boone. What's this? Have to clip what? Did I say something nice about you, darling? Do you have to clip me saying something nice about you? I take back what I said about you. All right, that's it. Let's go. Where's my song? Where's my song? Where's my song? And no one make fun of my song. Also, if you feel like getting into my comments section and sticking up for me, that's fine. Especially on my last stream or the stream before, my last Boone stream. Go for your life. It's fine. It's fine.
Her name was Ella. She was an Aussie. She was the fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud.
Bye.
Because she's an 803.